Good morning, everyone. Thank you all for being here with us. It's a great pleasure to receive our colleagues from Clifford Chance in the United States and in Europe in order to discuss with us, or better than that, to tell us what are the latest news on the antitrust in the Americas and in Europe. We have many interesting issues that are being discussed in there that will probably get here in the near future, so related or not to digital markets, big techs, but actually we are very, let's say, I am concerned with, let's say, the possible new policies around the new Brandeis theses that are being applied in the United States, especially with the new FTC Lina Khan. So I am afraid, actually, not more than concerned. I'm afraid that we're going to have to rediscuss many issues we are discussing here in Brazil. We are feeling that the authorities are being more restrictive with unilateral conducts. So the point is, we really, really need, and it is a great opportunity for us to better understand what is happening in the United States, in Europe, and specifically in England. So thank you all. I wish you all a very good panel. We will be here and we will be open to debate and to discuss with you anything related to antitrust that you may find interesting for us. Thank you. I pass the floor to Renata and Adriana. They will coordinate the debate and make the full presentation of our guests. Thank you all. Renata?
Thank you, Lauro, and good morning, everybody, or good afternoon for our colleagues in Europe. So we have the pleasure here to have our colleagues from Clifford Chance this morning. I'm going to present our guests for today's presentation. And just one quick message. We're going to receive questions on the Q&A session of the webinar. So if anybody has any question during the presentation, please feel free to write on the Q&A, and we will pass this to our guests so they can answer. So on the US side, we have two colleagues from Clifford Chance. We have Peter Mucchetti. Peter is an antitrust partner in Clifford Chance DC offices. He has a very extensive experience in antitrust investigations, in merger cases, and also in litigation. Before joining Clifford Chance, Peter spent almost 20 years at the U.S. Department of Justice, and where he most recently served as chief of the healthcare and consumer products section. So I'm sure Peter will be able to share with us his experience in both sides, in the public sector and also private practice. We also have Brian Concklin. Brian is a counsel at Clifford Chance Washington, D.C. branch. He has a lot of experience advising clients in compliance with U.S. merger control, regulatory review of mergers, government investigation, and also anti-competitive conduct. So Brian has been navigating through clients in the U.S. pre-merger notification and review process, but also has experience advocating on behalf of clients before the U.S. FTC and DOJ. And I'm sure he will be giving us a lot of experience about responses to second requests and remedies on the M&A side, which apparently has been increasing importance over the past few years or few months. So Adriana, if you want to introduce our colleagues from Europe.
Sure. So we have here Sue Hinchliffe, who's first as a friend, but also a partner at Clifford Chance, the London office. And she joined Clifford Chance after spending, I think, 4 years at GE. And before that, where she worked in various competition and antitrust matters across jurisdictions, supporting GE's aviation, power, healthcare, renewable business lines. And prior to working at GE, Sue was an antitrust partner in the London and Brussels office of a US firm. And we also have here Milena Robotham, who's a counsel at Clifford Chance in Brussels. She joined Clifford Chance initially in 2012 and recently returned after a 2-year period as a senior legal antitrust counsel at Oracle. So she has a lot of in-house and outside counsel perspective, and she's going to give us her perspectives on that. So without any further delay, I'll just pass the floor to Peter and Brian, who will tell us about the many recent US developments.
Good morning, everyone. Thank you very much for having us. We're very pleased to be here and honored to be speaking before all of you. I think to get things started for Peter and I, it's difficult to discuss the U.S. antitrust updates without at least taking a short discussion about the recent tech cases. We could spend the entire hour and barely scratch the surface on what's going on with the tech cases. Clearly, that's a high area of importance for both the Department of Justice and also the FTC, and then on top of that, private plaintiffs. But we did think it would be worth at least a short couple of minute discussion about what's going on in those cases currently and where they seem to be headed. Starting with the Facebook cases, as you likely are aware, both the FTC and states filed separate but very similar cases against Facebook. Starting with the FTC's case, as you may well know, in December of 2020, the FTC filed a claim in federal district court against Facebook, arguing that Facebook had engaged in a systematic strategy to eliminate threats to its monopoly position, citing specifically the acquisitions of Instagram and WhatsApp, and additionally citing to its conditioning access to its platform interconnections, otherwise known as APIs. In the suit, interestingly enough, unlike the state cases, the FTC only filed on behalf of a violation of Section 2, the monopolization, Section 2 of the Sherman Act, claiming unlawful monopolization. So as I noted, the claim largely is based on the previous acquisitions many years ago of both Instagram, which at the time the FTC claims was seen as a threat to customers moving away from social media needs on desktops to mobile devices, and then the later acquisition of WhatsApp, which the FTC paints as an emerging threat to mobile messaging. And additionally, the FTC cites to Facebook's conditioning access to its platform interconnections, again, otherwise known as APIs, to certain conduct or unlawful, unallowed conduct, I should say. So, for example, developers were unable to offer some of the same features that Facebook offered, and they were also unallowed to connect or promote with other social network platforms. If they did, they would have been kicked off Facebook. Most recently, on June 28th, the judge in the matter dismissed the FTC's complaint, but not the entire case. The judge gave the FTC 30 days to file an amended complaint, and then most recently gave an extension to mid-August for that amended complaint. Most importantly, the court found that the FTC had failed to plead enough facts to plausibly establish one of the necessary elements of a Section 2 claim. Namely that Facebook has a monopoly power in the market for personal social networking services, otherwise known as PSN. The court found that it was possible and plausible that the PSN is a relevant market, but that the FTC's complaint failed to show that Facebook has a monopoly power in that specific product market. Regarding the platform policies, the court took a somewhat different stance, and the court acknowledged that Facebook's policies did not violate Section 2 of the Sherman Act. It stated that Facebook's implementation of the policies, on the other hand, could have been a violation of Section 2. However, at the time of the suit, Facebook was not violating or about to violate Section 2, which is required under 13B of the FTC Act. The case was brought under 13B of the FTC Act, which allows the FTC to seek injunctions for conduct. The court ruled that the conduct was many years ago, and therefore it would be unnecessary to order an injunction or rule on the matter for conduct that no longer was occurring. The court also, interestingly enough, rejected Facebook's argument that the FTC lacked the authority to seek an injunction against the acquisitions of Instagram and WhatsApp because the mergers happened years ago. The court acknowledged for the FTC's claim that, in fact, the mergers had taken place many years ago, but that Section 2 did not necessarily prohibit the FTC from seeking an injunction for those matters or seeking a remedy. In the state case, it was quite different in terms of the current outcome. Similar to the FTC's claim, 48 attorneys generals from 46 states, including DC and Guam, again accused Facebook of suppressing competition through its monopolistic business practices. Interestingly enough, separate from the FTC's claim, the states argued that it was both a violation of Section 2 of the Sherman Act and also Section 7 of the Clayton Act. Speaking kind of from a strategic point of view, the states claimed a Section 7 violation, while the FTC stayed away from that, largely because the FTC had previously authorized the previous acquisition. So it was going to be difficult for them to now claim a Section 7 violation. But going back to the judge's decision, in June, the judge dismissed the state's claim, arguing that the claims were barred by the doctrine of lashes, which in the US is a common law equitable defense based on the notion that the plaintiffs had waited too long and delayed their rights to bring forth an action, and that the delay in bringing forth the action prejudiced the defendants. The court cited to a number of cases that generally determined that 4-year statute of limitations was appropriate for an injunction. Here, the court also cited to the fact that the states chose not to assert their concerns about the WhatsApp deal or Instagram deal, despite the fact that that some of the analysts at the time and press releases at the time made the exact same complaints and claims that the FTC and the states were arguing in this matter. So again, the court dismissed the states' claims. The states are now appealing the court to the Court of Appeals for DC and filed such on Wednesday. There's no substantive information that we can provide on what their appeal to the court said, other than noting that they were appealing the decision. So with that, I'll turn it over to Peter to give a quick update on where the matters stand against Google.
Hi, everybody. It is great to be here with you. It is such a crazy time in the antitrust world right now. There are all these cases every day. You see certainly new tech cases, but also new precedential cases, whether it's concerning damages or new theories. There's an unprecedented amount of coordination among enforcers throughout the world. Theories in one country or an agency practice in one country influences the practices in other areas. So let me just kind of quickly go through one more case that was just recently filed against Google. The state of Utah and 36 states here in the US have added their own challenge to the accusations that Google monopolizes the Android operating system and the distribution of apps on that system, and this in-app payment system where charges that are going through these programs, Apple and in this case Google, take a cut. Just today there were 2 more cases filed against Google throughout the world. And one of the things I wanted to point out is we're really in an interesting time in terms of what precedent is going to be set. We've seen a bunch of investigations that have now matured into lawsuits, and we're just now beginning to see those decisions in the lawsuits, which are going to give us the precedent and set some of the rules of the road for the years ahead. We saw the state attorney general's loss in the Facebook case. That's now getting appealed. Very interesting that they decided to appeal it instead of just filing a new complaint and starting over. So when we get a decision from the appeals court and perhaps the Supreme Court about whether the state attorney general's claims against Facebook were viable or not, that will be a valuable precedent. Another big decision that we're waiting for soon is Epic's case against Apple here in the United States. We expect that that decision is going to come down in the next few weeks, and that will be the first time that a court has weighed in on a permanent injunction basis on whether these theories against Apple for in-app payments and the App Store, whether they're viable, what is Apple liable for? And then even in the cases here in the District of Columbia that the government has, that's now proceeding through litigation. Although on that one, I wouldn't hold my breath. They're not expecting a decision until at least a couple of years here. And of course, there'll be a lengthy appeals process for that too. Well, let's move off of the tech matters and just very briefly touch on another area that has been in the news, and that is this idea of the agencies challenging nascent competitors, emerging markets. That idea has really caught on. You see that in the FTC's challenge of Facebook's acquisition of WhatsApp and Instagram. But another great example of that is the Justice Department's successful challenge of the Visa-Plaid merger. There, Plaid was a company that was looking to challenge Visa on online debit payments. DOJ brought the case, the parties abandoned the transaction rather than litigate with the Justice Department. But really it stands for the idea that the agencies are focused on where you have an allegedly dominant company acquiring a startup, including cases where that company hasn't achieved significant share yet. They're really asking that question of, does this company have the potential to become a big competitor? And if so, they're really focused on that. Brian, maybe I hand it back to you to talk about the Axon matter, and then we'll hand it over to our European colleagues to give us their developments.
Sure. Thank you, Peter. As Peter mentioned, it's unprecedented times, and certainly the agencies are being more aggressive in the U.S. than we've seen in the past. And I think the Axon, the FTC matter is a prime example of that. Axon in 2018 acquired a company called Vivu for $7 million, well below the HSR notification thresholds, which are currently set at $92 million. So the deal was not notifiable. Nevertheless, the FTC sued to block the matter. It alleged harm in the markets for body-worn cameras and digital management systems for large metropolitan police departments. The FTC, interestingly enough, demanded not only that the deal be unwound, but also demanded that Axon, the buyer, include some of its own IP in the divestiture to help prop up a competitor. Clearly, this was an overreach according to Axon. So Axon brought suit against the FTC in court, arguing that the FTC's process and its adjudicative procedures were unconstitutional violations of its due process rights. As they deemed it, the FTC's clearance process, the determination of whether a matter goes between the FTC or DOJ, is what they called a black box clearance process. And there are different standards and procedures between the FTC and DOJ, which we all know. And those differences violate Axon's due process and equal protection rights. They also argued that the FTC's structure for administrative Part 3 proceedings, which are separate from the way the DOJ brings matters, also violate its due process rights. And they specifically pointed to the FTC's 25-year win streak in challenging matters before their administrative process. In April 2020, the U.S. District Court for the District of Arizona granted the government's motion to dismiss. Axon appealed that to the Ninth Circuit. In a split decision, the Ninth Circuit affirmed the dismissal. And then in April 2021, the Ninth Circuit extended the stay of the FTC matter while Axon petitioned the Supreme Court for review. So that, again, that matter just really stands for the proposition that, as we come across frequently in the US, deals that are even below the threshold are not necessarily safe from scrutiny, particularly in today's very aggressive politicized environment. So with that, I'll turn it over to Sue. Sue, do you want to give an update on some very important recent cases that are occurring in the UK?
Sure. So it's interesting, listening to you guys talk about what's going on in the US and really about the increase in sort of active enforcement there. I have to say that that's a theme that resonates here in the UK, where really the regime is being characterized, I think, by the empowerment of the CMA and the UK government as a result of its exit from the rest of Europe. And we see that really, we've already started to see that, and arguably before Brexit, in the context of merger control by the CMA, where they are taking what we're politely referring to as a very assertive approach to merger control. If you look at the statistics that are published, and I know, I'm sure the competition authorities in Brazil did this as well, publish statistics on an annual basis about case enforcement. They make very gloomy reading for merging parties that are potentially looking at having to be subject to the review of the CMA. So just to put this in context, out of 12 cases in the UK last year that were subject to a phase 2 review by the UK CMA, 9 of them were blocked or abandoned, 2 were cleared with remedies, and only 1 was cleared without remedies. So that's a failure rate, if you like, of 75% for cases that are subject to phase 2 review. And 12 may not sound like a very high number, but considering the size of the CMA versus the size of the EU, for example, that is a relatively high number. And I think Milena would agree that the European Commission, deals that are blocked or abandoned are really, I would say, much rarer than that. So these figures really illustrate that the CMA is being very, very assertive in its approach to mergers. And one UK lawyer has quite famously now coined the phrase mortality rate for deals that are subject to review by the UK CMA. So things are not particularly rosy, and that's coupled with the fact that the UK is taking a very broad approach to jurisdiction. So as I'm sure you all know, we currently have a voluntary regime for mergers in the UK, and jurisdiction can be asserted on the basis of 2 tests. One is a very straightforward test based on the revenue of the target in the UK, which is a very simple test to apply. The other criteria for jurisdiction is what we call the share of supply test. So whether or not the transaction will result in a share of supply of goods or services of any description in the UK of at least 25%. And it's long been established that that is not an economic assessment of a relevant market. The concept of the services of any description is really quite, very broad. And it's long been established that there has to be an increment, and that the CMA has quite a lot of discretion in determining how it measures the 25%. So it doesn't have to be revenue, so it doesn't have to be volume, it could be volume, could be cost, prices, or even number of employees. But the CMA seems to have moved even further now in terms of trying to assert jurisdictions over deals which instinctively and historically wouldn't necessarily have been deals that you would have expected the UK to have the ability to review. So a couple of years ago, Roche bought a company called Spark Therapeutics. This target company had 0 revenues in the UK in relation to a product area that overlapped with Roche at all. But the UK CMA asserted jurisdiction on the basis of a pipeline product it said that Sparks was developing and that would eventually come onto the market in the UK to compete against Roche. And they established that there was a 25% share of supply on the basis of the number of employees that both companies had in the UK working in the relevant product area, which I think is probably a fairly unique approach to establishing, if you like, a market share or a share of supply test when you look at jurisdictions globally. I'm sure all of you will have heard of the Sabre Fairlogics case, which is another example of the CMA asserting jurisdiction very broadly. In that case, both companies are active, obviously, in the supply of IT services and information to airlines globally. Sabre had a business in the UK. Fairlogics had no direct customers in the UK and did not have any UK turnover. Nevertheless, the CMA found that the share of supplies test could be met by virtue of the fact that it supplied services and had contracts with American Airlines, and American Airlines had an interlining agreement with British Airways, and therefore it said that indirectly Fairlogic had a commercial arrangement with BA, which is a UK customer. And then in terms of establishing whether there was an increment to Sabre's 25% of that market, if you like, in the UK, it said actually, even though Fairlogics has no revenue and even though it doesn't have a direct commercial relationship with British Airways, it did derive value from the contract from BA, and therefore even though they couldn't actually measure the size of the increment and it couldn't be determined, there must be one, and therefore they established jurisdiction, which again seems really stretching the bounds of the test. Interestingly, that case was appealed and in fact was upheld by the Competition Appeals Tribunal in the UK, who basically said that in applying the share of supply test to CMA, it was a matter for the CMA's judgment and discretion. And in relation to the CMA's assessment of the increment, they said that it was not irrational for the CMA to have done what it did, which is a fairly low bar, frankly, for something not to be irrational for a competition authority to do. I won't take much more of your time on the UK. Just the only other case I might mention, which is not a merger control case, which is of interest, is in relation to Google's privacy sandbox. So I don't know how familiar you are with this. So Google was proposing to remove third-party cookies and other functionalities from its Chrome browser, ostensibly to protect the privacy of users from being able to see what users were doing cross-site. And the CMA stepped in because it was very concerned that those proposals would adversely affect the ability of third party to compete with Google and would somehow prefer Google's own services. And Google has been working closely with the CMA to enter into commitments, basically to structure its new sandbox, if you like, the privacy sandbox, in a way that the CMA will be happy about in terms of the impact it will have on competition. And it's an interesting case because it's all happened very quickly, all during the first part of this year, but also it's really almost an example of Google working hand in hand with the CMA proactively in advance of introducing a new policy to essentially get regulator sign off on the policy before it's introduced. And so I think it's quite an interesting approach, both from the CMA but also from Google. So Milena, let me hand over to you on the European side.
Thanks, Sue. Hello, everyone. So I'm going to pick up on what my colleagues have been speaking about and talk about some notable recent cases at the European Commission level. Before I dive in, I just wanted to pick up on, Sue, what you said about mortality rate. Just in contrast, I think my recollection was that there are 360 merger notifications last year at the European Commission level and 0 were blocked. So to paint a picture of the contrast with the with the CMA and the European Commission. And in fact, the European Commission has recently been disciplined by the European Union's highest court in not applying a sufficiently high standard of proof in its review of a merger in the Hutchison's acquisition of Telefónica's O2 in telecommunications space, a merger that was blocked a few years back. So quite contrasting approaches there. But the cases that I wanted to dive into in a little bit more detail are, on the one hand, some cases in the tech sector, investigations, new wave of investigations that we see at European Commission level And then I'll say a few words about some cases in the pharmaceutical sector. The fact of the European Commission having a number of investigations ongoing in the tech sector is not in itself new. As I'm sure you are all aware, the European Commission has been very vigorous in its enforcement in this sector and proud of its position as being at the forefront of enforcement in that regard. One of the pillars, I think, the theories of harm that sort of run throughout the European Commission's enforcement in tech, not just in the current generation, but in previous generations, is a focus on self-preferencing conduct. That is definitely present in the theories of harm in the current generation, but another new pillar that underpins the theories of harm is the role of data. And we see this parallel track running through enforcement in cases against Google, Facebook, and Amazon. Some of these dovetail with what's going on in the US and in the UK, but there are some important distinctions. The formal investigation that was opened against Google earlier this year is looking at Google's collection and use of data in connection with its digital advertising services. And Sue mentioned one aspect of Google's conduct in this space. That's the privacy sandbox, which Sue explained, and that is also being investigated by the European Commission. So it will be interesting to see how the developments that Google arrives at in dialogue with the CMA affect the investigation in Europe. Because of course, the European Commission is looking at the changes to Chrome and in the elimination of third-party cookies on Chrome as Google restricting access to key input data that competitors need to be able to offer their own advertising technology services that rival Google's. There are other aspects, other elements of conduct that the Commission is looking into. So even if Google does resolve and, let's say, arrive at a point where the privacy sandbox is not encompassing anti-competitive behavior under UK interpretation or EU interpretation of the rules, there's still lots of other conduct that the European Commission is looking at. This relates to data, indeed, but also to more traditional self-preferencing type conduct. For example, the European Commission is investigating whether Google is anti-competitively tying its advertising technology services with its dominant properties. In other words, does an advertiser, like any company, Nike or Ford or Coca-Cola or anyone, has to use Google's advertising technology services if it wants to show ads on YouTube? And is this an abuse of Google's dominant position? This two-pillar, role of the data, use of data, and self-preferencing conduct theories of harm is also present in the Facebook case. So the Commission just this month opened a formal investigation into Facebook's conduct. This differs entirely from the case that Brian and Peter described at the top of the presentation. The Commission is looking at Facebook Marketplace. So this is Facebook's online classified ad service that's connected to Facebook. And the self-preferencing angle is, does Facebook anti-competitively tie Facebook Marketplace to the Facebook social network? And the data angle is, does Facebook misuse valuable data that it has access to from rival online classified ads service providers when competing with them in a Facebook Marketplace, so in a different market? This is very similar to the theory of harm that the Commission is pursuing in the Amazon investigation, which has been running since last year, or in fact, perhaps the year before, where the EC is investigating whether Amazon is using data from sellers that it has access to because those sellers are selling through the Amazon marketplace to in its competition with them when Amazon has its own retail offering. That's the data angle. And the preferencing angle is that the European Commission is exploring whether Amazon favors its own services. When we as consumers search for a product, does Amazon favor results that are Amazon's own retail offering or offerings from sellers that use Amazon's logistics or delivery services? So these three cases are likely to establish a new front, let's say, and a new wave of standard of behavior with respect to data that I think will inform the Commission's enforcement going forward, but also the legislative and policy developments that are occurring in parallel that we'll come back to and discuss at a later stage. Conscious of the time, I'll say just 2 words about the pharmaceutical cases in the pharmaceutical sector to pick up on the Commission's use of the commitments procedure. So in February this year, the European Commission handed down a commitments decision, so a settlement decision in relation to the pharmaceutical company Aspen, on the basis that Aspen had engaged in unilateral anti-competitive conduct, excessive pricing. And the Commission came under fire for pursuing a settlement as opposed to a full-fledged infringement decision because of the arguably diminished deterrent effect of a commitments decision. But Commissioner Vestager has defended her approach, saying that this enabled the Commission to achieve a very swift resolution and to still demonstrate to pharmaceutical companies that might engage in similar behavior or companies in other sectors that the Commission is willing to move fast and to come down strongly. And finally, I wanted to mention the new investigation into the pharmaceutical company Teva, which has 2 theories of harm, both of which are novel, new at European Commission level. The first is product denigration, which is the Commission exploring whether Teva has engaged in a campaign of negative communication about a competitor's product to hospitals and medical professionals, and is exploring whether that can be an abuse. Now, I guess the ramifications of this maybe are self-evident, but I have a suspicion that the Commission might be trying to draw a line and define the parameters of when this can be an abuse. And I imagine that it might draw that line quite narrowly. And that is because we have seen a number of cases at national level, particularly in France, but also Italy and Denmark, where product denigration has been deemed to be an abuse. And those national competition authorities haven't drawn that border very narrowly. And this might be the Commission coming to try and right the ship. That's a personal view. Let's see if it's borne out. The other aspect of the theory of harm in Teva is about patent strategy. The Commission is looking at whether Teva's engagement in a patenting strategy of applying for very many child patents related to a parent that has expired, or divisional patents related to an old patent, is an infringement of Article 102, so a unilateral abuse of competition law. Also has the potential to have significant ramifications within the pharmaceutical sector, where this is quite a common practice, but also in other sectors, chemicals, where this practice is not uncommon. I'll pause there. I know that's quite a lot on the cases to digest, but I'll hand back to Brian and Peter so that we turn to some legislative and policy developments.
Well, Sue and Milena, thank you so much. I mean, it's just incredible the amount of activity that's going on in terms of investigations and cases, and it doesn't end there. There's also very significant changes in terms of personnel and possible new laws that are being considered throughout the world. But let me pick up on a point that Lauro made, which is Lina Khan's appointment to the FTC is definitely big news. She has been an outspoken critic of the tech industry. One of her claims to fame is that she wrote in law school an article called Amazon's Antitrust Paradox, taking on Amazon. She served on the House Tech Committee. All of this just 4 years out of law school, and she has taken the FTC by storm, holding public meetings and making many significant policy changes as well. I think it's very fair to say that she is looking to increase the amount of antitrust enforcement. She's looking to increase the scope of what the antitrust laws can cover. So definitely a lot more activity coming out of the FTC. If you're a company or a consumer group that is looking for more antitrust enforcement, this is a great thing. If you're one of the companies that's subject to that scrutiny, I'm sure you're thinking not so much. But I think one of the interesting developments that we will be waiting to see in the months ahead is who will become the fifth commissioner on there. You know, the FTC has 5 commissioners. Right now, 3 Democratic and 2 Republican, but one of those commissioners, Rohit Chopra, is expected to eventually work his way off the FTC and go over to a new federal agency. So if and when that happens and there's a new person who replaces Chopra, that person could become the swing vote. The other Democratic commissioner, Rebecca Slaughter, also very aggressive, looking really to aggressively enforce the antitrust law. So something to keep an eye on is who replaces Chopra. Will that person be also similarly aggressive or more of a traditional mainstream Democratic voice, in which case that person would become the swing vote. Then over at the other federal antitrust agency, the Antitrust Division of the Justice Department, my old agency, they have, after 6 months, nominated Jonathan Cantor to be the Assistant Attorney General in charge of the antitrust agency. He used to be at Paul Weiss, went off to have his own firm, has been a vocal tech critic as well. But having said that, he is viewed as more of a mainstream Democratic choice, with the exception of the tech industry. But for other industries, the people who are looking into our crystal ball and we're thinking he understands the issues on both sides. And one of the questions is, to what extent will he and Lina Khan be conflicted off the tech cases? And it's not just DOJ and the FTC that are getting into this fight, it's also the White House itself. Brian, can you tell us about the sweeping new executive order that the Biden administration issued earlier this month?
Sure. Just quickly before I do that, Peter, I just want to touch on and elaborate on one point you made, which was these public hearings that the FTC is having under Lina Khan. I would note that, importantly, there is some significant pushback, particularly from Republicans, on that although it sounds fair and very American to have these open forums, they are anything but public and fair. There are at least notions and claims that I would say there are 2 sorts. The first is that the decisions that are being made at these public hearings are being made well before the public has any chance to comment or make any decisions. So it's really make a decision, ask questions, and get feedback later. There is also pushback, at least from Republicans, that perhaps Lina Khan and the other Democrats are making decisions without really taking the input of the Republican commissioners, such that it's not really a true bipartisan commission at the moment. We'll see how that plays out, but there is pushback on that front. And in fact, some of the Republicans have recently written 2 letters to the FTC raising concerns on those 2 fronts. But with that, I will turn to what's going on with the White House. We heard a lot of rhetoric during President Biden's campaign of the importance of antitrust. Antitrust was certainly at the forefront of politics, really for the first time in quite some time. And as Peter pointed out, on July 9th, as you may know, the president signed the executive order on promoting competition in the American economy. For many of us in the bar in the US, really, to the extent that it wasn't already clear, the executive order is what I would call a call to arms for more than a dozen of the U.S. agencies beyond the DOJ and FTC to start taking action. And although the executive order indicates that the DOJ and FTC are certainly what are referred to as the first line of defense in enforcing the antitrust laws, there are many other agencies in the U.S. government that play a part in enforcing the antitrust laws and enforcing the fact that there needs to be fair and ample competition, and they do so through their industry-specific laws and also implementing industry-specific regulations. The order included 72 initiatives calling for heightened antitrust scrutiny. You need to remember that this is an executive order that's calling for initiatives. It is not a law in and of itself. So in many instances, it was encouraging the agencies to take certain types of action. Or encouraging and demanding that certain agencies provide regular reports to the White House on how their enforcement policies are going. I think importantly, the order also established a White House Competition Council. The council is tasked with, and I quote, working with federal agencies to ensure that the agency operations are conducted in a manner that promotes fair competition as appropriate and consistent with applicable law. So certainly you see more oversight from the White House into how the agencies are enforcing the antitrust laws than really ever before, certainly in quite some time. The order made, as I mentioned, a number of recommendations to the various federal agencies. It would take an hour for me to just go through what each of those are, but I think some of the most important ones are the FTC and DOJ were encouraged to re-examine the horizontal and vertical merger guidelines. And just that day, the executive order was signed. Both the FTC and DOJ came out with a joint statement indicating that they would do so. The FTC and DOJ were encouraged to consider rulemaking regarding unfair restrictions on third parties' abilities to repair devices and equipment, particularly in the cell phone and agricultural space. The FTC was asked to take a look at and eliminate non-competes and non-solicitations. Certainly, employee rights was a key part of the executive order, and the free movement of labor is a theme that we're seeing throughout, both at the federal level and also at state levels, which are challenging non-solicitations among employers. The rulemaking also was asked to address unfair data collection and surveillance, and the FTC was asked to develop rules regarding unfair methods of competition by online marketplaces. So again, we're seeing a focus on digital platforms. So what does this order really mean? I think taking a step back, we're going to continue to see increased merger scrutiny, particularly in deals in the sectors that were called out in the order, such as agricultural, transportation, personnel and employee rights, among others, and then of course, digital platforms. We're likely going to see a surge in new rules implemented by the federal agencies, and we're going to see an increased likelihood that the U.S. antitrust standard is going to shift away from the consumer welfare standard as we all know it. This really is, again, more and more rhetoric that we need to move to something away from the consumer welfare standard and something more holistic. So Peter, with that, I think you want to talk about some of the most recent bills that were proposed in the House.
I'll tell you what, I'm going to hold that in case we have some time at the end, which I suspect we're not. So actually, because I want to make sure we get to the EU and UK developments. Sue and Milena, can I hand it back to you to give us the recent legislative updates on the other side of the Atlantic?
I'll just do very, very quickly. So, I mean, because what's going on in the US sounds so dramatic. The UK was going to seem very boring by comparison. I did just want to say that although the UK doesn't have a whole, hundreds of cases or hundreds, but such significant case, I guess, against the large digital platforms that is going on in the EU and the US, they're not being left out. So they have established just earlier this year something called the Digital Markets Unit, which sits within the Department for Business, Energy and Industrial Strategy. So not within the CMA, but is side by side, if you like, which is it. And the full scope of what that unit's going to be tasked with is not yet clear. There are proposals being consulted on about a possible code of conduct for large digital platforms, and that largely the Digital Market Unit will be responsible for policing, if you like, adherence to that code of conduct. So they are wanting to have their say in the digital arena, and they are doing some investigations. They're using their market investigations or market study tools to look at Apple and Google's mobile ecosystem. That was a project that, a study that was launched just in June this year. More generally, though, and more along the theme of sort of the CMA and the government flexing their wings a bit, now that they're not within the EU, is that the government recently issued consultation on a proposal that would result in a number of changes to the UK antitrust rules generally. One of them, I'll just sort of mention a couple. Some of them are very specific in the detail, but one of them is quite important, which is the government wants more oversight or more influence into the strategic direction of the CMA. And so they're going to be giving that, I think these new rules will allow them to intervene more, and not, I think, necessarily in terms of the specific cases, but more the sectors that it wants the CMA to focus on, and sort of general strategy. So when that comes in, it'll be interesting to see how strongly the government relies on that sort of ability to influence the direction of competition law policy. Just lastly, just to say that proposals are not on the table to change the UK's merger control system from voluntary to mandatory, but the government is looking at maybe increasing the revenue threshold and potentially applying the two thresholds, so both the revenue threshold and the share of supply test, allowing that to be applied to just one party only. The theory being that therefore you would be able to capture transactions with a large buyer who is, wanting to buy a small target. So that would allow the UK to be able, CMA to be able to capture killer acquisitions more easily. So Milena, let me hand over to you for the EC highlights.
Thanks, Sue. And the EC highlights, are in some ways very parallel to the UK ones. I'll take them in the same order. So whereas the CMA has introduced the digital markets unit and is exploring the conduct of platforms and so on, and regulation thereof or enforcement in relation to those platforms, at the European level, we have the Digital Markets Act. At the moment, this is just a legislative proposal. It's making its way through the process, through the Parliament, and the European Commission has sponsored this piece of legislation, which would designate certain companies as gatekeepers. And these companies, it's designed in such a way as essentially to capture only 5, maybe 6 companies. So the very biggest platforms, we say, the GAFA, Google, Apple, Facebook, Amazon, with the addition of Microsoft, and the MEP, who is the steward of this legislation, has also added Alibaba to that list. And it would require these companies designated as gatekeepers to ex ante comply with certain obligations. So without a full-fledged competition investigation, they would have to inform an authority of planned mergers. They would have to comply with data separation, data use obligations, implement interoperability requirements, and they would have prohibitions on self-preferencing. So this is the other side, if you like, of the enforcement that I talked about earlier, with the Commission essentially trying to preempt the position it's in now, of trying to correct the market after the conduct, after the fact, and ensure that the conduct never takes place in the first instance. We've mentioned the word overreach a few times, and of course that's a word that's being bandied about in relation to the Digital Markets Act also, depending on which side of the debate you're on. The other parallel, so Sue mentioned while the CMA is not exploring making merger notifications mandatory, there are some changes in how the CMA might look at mergers. And we have had a recent policy change at European Union level with respect to Article 22, which many of you will have heard of, I'm sure. Article 22 of the EU merger regulation is not new, but it enables member states to refer a merger for review by the European Commission where that merger does not trigger European Union level merger notification thresholds. And previously, the Commission explicitly discouraged referrals in situations where the member state was not itself competent to review. In other words, where the merger did not trigger that member state's national merger control review thresholds. Now, the European Commission has done a 180 and in March stated that here is our answer to the killer acquisitions problem. We are not going to change our merger notification thresholds, but we would like you, member states, to refer mergers to us that may significantly impact competition, even if there's minimal turnover. This is intended to capture exactly cases that Sue mentioned, where the value is in complete different relationship to the turnover, such as startup companies, which may have no turnover, but may be valued in the billions, or companies focused on R&D, or pharmaceutical companies that have something very innovative in the pipeline. And we've seen the first cases, referral cases come through. There's Illumina Grail, and there's Facebook customer with a K, 2 cases, which are now either in phase 2 review or about to enter phase 2 review, 2 cases that did not trigger notification thresholds at the EC level or at member state level. So a substantial policy difference that will significantly impact companies, particularly in the tech and pharma sectors, and in their business certainty and planning for acquisitions, and certainly something that we will be watching closely.
And Milena, am I correct in that with this new? Sorry, just real quick, Milena.
Go ahead, Brian.
With this Article 22 change, wasn't it correct that the European Union went out and proactively sought member states to refer the case to them?
That's right. So the policy guidance issued in March by the European Commission says you member states are now able to refer, but in practice, what we've seen is that it is a tool for the Commission to request that member states refer a case. So where the European Commission decides it would like to review a certain case, it will go and ask. We have seen member states start to push back, actually. Just a few days ago, last week, Germany explicitly noted that it doesn't view this approach to referrals as compatible with its own national policies. And so we see the potential for friction here. Spain has said something similar also in relation to the Facebook customer with a K acquisition, Slovenia also. So there's some interesting fights perhaps setting up in how this Article 22 is implemented in the future. I think I see a hand raised.
Yes, that's me, Lauro. Sorry for interrupt, but I have a question about that. I understood that the Commission can call for other states to refer the cases, but does the Commission has the authority to call for the involved parties, to notify a notifiable transaction? Without, if the transaction is not filed with any of the states, is it possible for the Commission to call it?
It is, but through the Article 22 procedure, procedurally, the Commission would have to go the route of requiring the member state to refer it. So in practice, it has the same effect, Lauro, because if the Commission sees, I would like those parties to notify, it could approach them directly. But the Article 22 enables it with a tool, provides it with a tool where it doesn't have to do that, but it can arrive at the same result. Now, Illumina Grail resisted, they initially having their proposed acquisition referred to the European Commission, refused to notify it. And in fact, they fought it at the courts, and they still have a case pending at the European Union General Court. But seeing that they were perhaps unlikely to get success in the short term, decided to notify and then even voluntarily offered informal commitments to the European Commission, which were not accepted. And so now they're in a phase 2. So it really is a powerful tool that the European Commission has at its disposal.
Thank you. Because here in Brazil, in accordance with our competition law, CADE, the antitrust authority, has 1 year term to call for a transaction that is not notifiable according to the law. So if you make a transaction and until 1 year after the transaction, if it is not filed, CADE can call for it, for the review. But after this 1 year, actually, I understand that CADE has no more power to do that. So it is done. I don't know if there are similar mechanisms in the European Commission, in England, or in the United States. I understood that Lina Khan wants to call for past transactions, but I don't know if there is a term in any of the jurisdiction to do that.
It is a really odd feature of US law that there is no statute of limitations for the Justice Department and the Federal Trade Commission to challenge a transaction. So in theory, they could challenge a 20-year-old merger. Now, as a practical matter, they very rarely do that. And the older the transaction, the less likely they are to do it. But the FTC's challenge of Facebook's acquisition of WhatsApp and Instagram, those were transactions that happened in 2011, 2013. So they did reach very far back. Now, I will say, I think that's going to be the exception. We're going to see a challenging of transactions that have already closed, especially so far in the past. I think that will continue to be very rare, but it is possible.
Thank you.
I would just add.
Brian. Yeah, please. I was going to ask that.
No, I was just going to add. I think it's going to be very sector specific. I think in the tech sector, as we've seen, there'll be close scrutiny on deals that may have closed without notification. I think that may also be the case in pharma. I think in some other sectors it may be less risky, but those seem to be the areas of most concern to the regulators. But certainly, as noted in the other case I mentioned, just because a deal is not notifiable does not mean it cannot be challenged at any point.
That's very interesting, and thank you, Milena, Brian, Peter, and Sue. As I think Peter mentioned in the beginning, there's so much going on in all jurisdictions about antitrust policy, new laws, new theories of harm that we could spend the whole day just talking about what is happening in each jurisdiction. But one thing that, and I will leave the floor to people to ask questions if they have. I do have one question. After listening to the presentation, I was putting myself in the place of in-house counsel, looking on a global company that has activities in many jurisdictions and all these movements. And I feel like I'm in this big highway where you could go straight ahead, you could go right, you could go left, but you don't have a map, so you don't know where you're supposed to go. And my question for the follower of you, if you want to comment, is how do you see the authorities interacting with each other and trying to get some consistency on what they believe it's an issue or not? Because we are seeing now, as Milena mentioned, the European Commission doing new theories of harm that may be in the same line of what the US is looking for, but maybe not, because this is all very new and all very subjective. And then you see the UK maybe looking more as a proactive role in looking at mergers and not giving the companies the chance to become as big as some companies, so they don't have this problem in the future that look into behavior. So I want to listen to your comments on that.
So I might let Peter answer that from his time in the government, but I just wanted to add, from somebody who's only been out of the in-house role for a very short period of time, that your observation is completely correct. And actually, for the, I don't want to introduce another topic into the conversation, but of course, when you're looking not just at the merger control regimes that are now increasingly challenging globally, but also have to think more and more about foreign direct investment and those sorts of legislations and notifications on top of merger control, and indeed the subsidies legislation in the EU. The number and complexity of potential filings that you have to do is just becoming incredibly onerous, and therefore I think that, you know, coordination is between agencies and trying to streamline that is going to be something that I think companies are going to be calling for more and more. But Peter, you maybe will have some observations from your experience in government.
Well, a couple of thoughts, and I agree with Renata that we are seeing a lot of coordination across governments, and I think we definitely see one antitrust agency in one part of the world influencing the other, and that tends to, recently that's been in the direction of being more aggressive. I don't think we've seen a lot of agencies calling for a greater understanding of the efficiencies that have come along with transaction and a respect for the contractual restrictions that are necessary to promote efficient conduct. We're not hearing that message. And so the agencies, I think, are pushing each other to be more aggressive in their theories. But having said that, the rules still exist. The agencies, they do absolutely care about whether a transaction is going to help consumers. They are looking at the facts of any particular cases, and it is easy to actually find many examples of transactions where the agencies let a transaction through or really did take a specific view as to the facts and the legal theories for their own jurisdiction. And I would say one example of that is the Aon Willis Towers Watson transaction. The merging parties there were able to achieve remedies with jurisdictions in parts of the world, including Europe. Ultimately, here in the United States, the Justice Department challenged the transaction and the parties abandoned the transaction. But it's interesting that you had regulators coming out in different places showing that, you know, ultimately regulators are going to make a decision based on their own market facts, on their own law. And so you will still see the agencies have this potential for divergence, which unfortunately from emerging companies' point of view is actually the concern, which is, you know, if you're going to be subject to merger review in 70 jurisdictions and you manage to get clearance in 69, but the 70th one is going to hold you up, it does make it really challenging. And there are many lessons to be learned from that. But one of them is that companies have to plan for a greater likelihood of investigation, a longer investigation timeline, a greater possibility of litigation, and a longer litigation timeline, and think about all that when thinking about, for example, the outside date in their merger agreements. This is the new reality. I think also part of the new reality is that whenever you have a new administration, they tend to take longer in making their decisions because they're still trying to decide, you know, which of these decisions are routine and which of these decisions actually do need greater investigation. So I think right here at the beginning of the administrations at the FTC and DOJ, that's just one more reason that we would expect longer investigation timelines.
Thank you, Milena and Brian. I don't know if you want to add something. Otherwise, I think Adriana also has some question.
Yeah, I mean, I have many questions actually. You know, we can stay the whole day making questions, but you know, my questions to Peter and Brian is that the FTC recently, well, Milena recently said that she intends to use, you know, the full powers allotted to the FTC. And I think my question is, what does that mean in practice?
So I'll start with that. You know, I think interestingly enough, the FTC does have broad powers. I think one, as called for in the executive order, is the ability to put forth regulations, and in part regulations, in part rules, and put those in place. So, for example, we could see some more rulemaking that would prohibit certain conduct or the like. The FTC also has broader authority when it comes to the FTC Act. So, for example, conduct that may not necessarily violate the Sherman or Clayton Acts, they have Section 5 of the FTC Act, which is much broader. But I also think that we have to keep in mind that the FTC does report and it does have some oversight. Its decisions are not carte blanche. Most recently, we saw the Supreme Court strike down the FTC's ability to seek financial remedies under their 13B powers. And so while there is some legislation to possibly reinstate that authority, their decisions are not, without some review. And so we need to keep that in mind, and we need to keep in mind that there is Congress pushing back on some actions of the FTC. That said, this is certainly a very aggressive FTC and a very aggressive Minacon. And so it's difficult to say where she may try to take the direction of the agency in terms of policies, regulations, and the amount of mergers that they challenge and review. Again, I would also just note that they, for at least for now, they do have limited resources, and so she needs to, as much as she or the president want to have this very broad, aggressive antitrust policy, there's only so many staff at the agency and almost only so much work that they can do. And so they're going to need to pick their battles, I would say. Peter, I don't know if you want to point out anything more.
Well, maybe just picking up on the point about resources that the Federal Trade Commission and the Justice Department have for many years, really at least a decade. Both agencies have been saying that they're under-resourced. And if you look at the numbers, their budget has declined in real terms. And certainly when you compare that to the growth in the American economy, that's another way to say that in comparison, the size of the agency's budgets have been shrinking. And we're at this point now where there actually does seem to be consensus to give more money to the FTC and DOJ. One of the pieces of legislation that is being proposed in Congress and actually has a very good chance of being passed is legislation that would increase the merger filing fees. For the largest transaction, the merger filing fees would be $2.25 million. For just the filing fee is $2.25 million. And the thought is that money could be used or earmarked for the agencies hiring more people, attorneys, economists, paralegals, support staff. And I think perhaps as Sue can attest, when agencies get more money and have more staff, they engage in more investigations. Maybe, I don't know, Sue, if you have any observation about the amount of resources.
Well, that's certainly the theory behind some of the comments that have been made about the CMA, because the CMA staffed up considerably in anticipation of Brexit happening earlier than it did. And there was a lot of, allegedly a lot of pent up frustration that they were not able to sort of get on and start reviewing cases that they thought that they would have been reviewing had the Brexit sort of not been somewhat delayed. And so that is apparently one of the explanations of their more aggressive stance. But whilst I think that might explain their sort of maybe the number of cases that they're sending to phase 2 proportionate to the overall numbers that they see, and of course they actively go out and look for cases. They have a market intelligence unit that goes out looking for cases that aren't notified, etc. I'm not sure it necessarily explains the mortality rate of deals that go before them, because that seems perhaps more of they would say that they're just doing their job better than other competition authorities, I guess, by identifying, some SLC concerns. But I don't know if, I thought when you were talking though, one of the things I always think is very interesting about the US is that you have the federal agencies, but then you have the states as well. And I just wonder if the intention of staff of investing more in the DOJ and the FTC is to try and make sure you don't have too much duplication of activity in the competition law space, but actually to try and centralize it a bit more. But perhaps that's too optimistic.
No, I think the state attorney generals are very independent. They are separate sovereigns, and they have, especially in the past 5 years, really invested more resources into their antitrust components, and have brought actions where the federal government did not. And I think that trend will continue. They believe in vigorous antitrust enforcement. They've got the knowledge now that comes with the experience of having brought their own cases. And so I think, if anything, we're going to see continued and increased antitrust enforcement from the state AGs.
Thank you, Peter, Susan, Brian, Milena. I still have a lot of questions, but I'm conscious of time, and so I will give the word to Lauro, who wants to say a final words. And again, thank you all very much, and our participants. Lauro. Laura, I think you're on mute.
Sorry for that. I was listening to Milena's speech, and it brought my attention to, like, say, the antitrust view of patent rights, IP rights, meaning that it seems to me that as in the big tech, let's say, attack by the authorities, it seems to me, and here in Brazil, there is also a more broad discussions about the abuse of patent rights. And it seems that this is the next, let's say, challenge for the antitrust authorities, and the antitrust authorities are willing to enter into the discussions between the antitrust and the patent rights, the terms and the abuse of dominant positions due to patent rights. Do you see this happening? I saw that, I understood from Milena that this is happening in the European Commission. I'm not sure if I understood correctly, but do you see that as a move also in the United States and in England? Meaning, after these discussions about the patents and with the vaccines for COVID, it is a trend that we can see in the future, more challenges of the patent rights and the patents rights abuse?
I think I think that might be a question for the US and the UK, but just if I round off on the EU, I think we have seen two waves, I think, of focus on the interplay, two waves in recent years, in the last decade, on the interplay between competition and patent rights. And I think the first with AstraZeneca, the European Commission decision, forgive me, I forget the exact year, but the instance in which the Commission found that AstraZeneca, in its application for patent protections, actually it provided misleading information to obtain that patent protection. That's sort of one category of abuse. And then you have the wave of standards essential patents related cases, in the FRAND cases, the commitment decision coming out of the Samsung case, and Huawei ZTE preliminary judgment. And I think what we might be seeing with Ativa is a new phenomenon that looks at a pure patenting strategy that is quite common. So I think, just to add that framing before I hand over to see if there's anything similar happening in the US and UK.
Well, I was going to say that there is this debate that we constantly have about patent rights are good because they encourage innovation. It gives people a return on their investment. And if we're going to have, new drugs, new inventions, you have to have that incentive. in order for people to have the economic ability to make these very large investments that take to bring, for example, a drug to market. But if there is one area that on the edges, there is scrutiny, it's the pharmaceutical industry. Yesterday, a Senate Judiciary Committee passed out some new bills that would make some restrictions on pharmaceutical rights in certain areas that have very much been in the news. Product hopping, pay for delay, sham litigation, and just to explain one of those, product hopping is the idea there's an existing drug on the market, the manufacturer pulls it off the market allegedly in order to force people to go to a new drug that is going to be on patent for a longer period of time. And the legislation that's being considered would address these specific situations in order to, in these situations, restrict the ability of pharmaceutical companies to take those specific actions, which have actually long been challenged under the existing antitrust law. So in some sense, they might bring clarity or define what is and isn't allowed. But there is interest in Congress in some sense in using legislative rights to the legislative process to address what's the proper scope of patent rights in those situations.
Thank you.
And that was also addressed. That was also addressed in the President Biden's executive order. One of the, I didn't mention this previously, but he did note in the order, one of the areas was to re-examine IP rights in the pharmaceutical sector, particularly the ability for parties to enter into pay for delay contracts, and whether that need to be re-examined and potentially prohibited.
So from a UK perspective, I mean, I would, you know, and Lauro, to sort of get to the point that you raised to think about COVID and you know, the patents around the vaccines and things like that, where there's been some press coverage. I think that is not, insofar as it's being looked at all in the UK, I think that it isn't really something that's falling within the remit of the CMA. So what the types of cases that Milena and Peter, you know, are basically abuse of the patent system to prevent third-party competition. So those sorts of cases, that's not really what I think of in that when I'm thinking about, you know, concerns around people having patents over vaccines to deal with COVID. That I think of more as being actually a government policy sort of approach. And what we have seen in the UK is that they expanded the scope of their ability. So the UK government can intervene in merger cases on public interest grounds. The number of public interest grounds have historically been very limited, but they did at the beginning of the pandemic expand the list of public interest concerns that could be raised to include, you know, protection of the ability of the UK to defend itself against a health pandemic. So it's sort of inserted, it legislated to allow itself to insert itself in mergers, at least where it thought that maybe it was somehow that the ability of the UK government to protect to keep patents in the UK for UK people would somehow be wrapped up in that. So we've sort of seen a response to the pandemic in that sense in the context of patents, but not a real upturn in pure competition law cases around patent issues.
Thank you. This was again very interesting. But now I can see that we have passed a lot the time that we have agreed on. So with that, I thank you all, and I'll give Lauro the chance to say the final words for this event. And thank you again.
Well, thank you all. It was really a pleasure. Thank you for all our panelists, and thank you for the audience. And it was a great panel. So I have so many questions about everything that is happening, and I will check. I will read this executive order. It seems to me very strange for Brazilian standards to have quite this kind of executive order by the president, because it's not allowed. It's not something similar to the Brazilian law. So I'll give a read that, and I'll call you if I have any other doubt. Thank you very much. Very, very interesting all.